Access to justice. Let us return to discuss the access to justice issue. As we have seen, an adversary system may be justified as a way to find truth and justice, provided that all can adequately participate in the adversary system. How well is American society ensuring that all members of society can participate in the justice system? In the early 1990s, the ABA commissioned a national legal needs study. The legal needs study interviewed people about problems that members of their household faced in the last year, what was done about the problem, and how satisfactory was the solution. Approximately half of all households, moderate income households meaning the middle 3/5 of the population, and poor households, living at or below 125% of the poverty line, faced some situation that had raised a legal issue in the prior 12 months. While most households did not seek legal or judicial solutions, the poor were markedly less likely than the middle income to do so. The poor were also mostly dissatisfied with the outcome, while the middle income were mostly satisfied. Both poor and middle-income people were more satisfied with the outcome when they did take the matter to the justice system. Since the national study was completed in 1992, there have been multiple follow-up studies in various states, including in Utah. Most of these studies conclude that 80% of the legal needs of the poor are not addressed by attorneys in the legal system. In Utah's study, the respondents rated the seriousness of their needs, and most of these needs were ranked as serious. How do poor individuals access legal services? The first legal aid societies were formed in the late 1880s and early 1900s as private charities providing mostly family law assistance to deserving clients. The Legal Aid Society of Salt Lake is the successor of this movement. In the 1960s War on Poverty, the federal government began funding free legal services to the poor. Early programs focused not only on providing basic legal services, but on law reform. For example, litigating to establish certain due process rights for welfare recipients and habitability for tenants. Litigation victories resulted in political backlash and restrictions to what these programs could do. The most recent restrictions were imposed in 1996 as part of the law ending welfare as we know it. Programs such as Utah Legal Services that receive federal funding are prohibited from filing class actions, from legislative lobbying, and from representing various classes of individuals, including incarcerated persons. Funding also increased and then was cut back as restrictions were imposed. Today, federal funding is about half of what it was in 1980, the high water mark. Since the federal cutbacks and restrictions that began during the Reagan administration and continued with the Clinton administration, various states have sought state and local government funding to replace the lost federal dollars. In Utah, the And Justice for All organization supplements funding for Utah Legal Services, the Legal Aid Society, and the Disability Law Center through robust fundraising from the private bar. At the same time, many states, through the judiciary and the state bar, have developed state plans for access to justice. The concept is to coordinate the delivery of legal services by calling upon pro bono attorneys to work in concert with the governmentally and charitably funded staff programs. Courts, too, have stepped up to provide forms and instructions for pro se parties, often individuals who are too poor to hire an attorney and who are not among the lucky few to be represented by the staff programs. Critics have argued for these and additional solutions. Some think that we should relax the unauthorized practice of law restrictions to permit paralegals to assist low-income individuals with legal problems. Some argue that our adversary system must change. We should rely more upon alternative dispute resolution processes, and judges and clerks can be more involved in ensuring that pro se parties have their cases appropriately considered. I wish that we could conclude this unit with the optimistic view that we are working ever more effectively to provide access to justice for all. While there has been progress, over my legal career there has been more lost than gained. There remains much to be done by those who take seriously our special responsibility as public citizens for the quality of justice. Thank you.